welcome to another episode of Simplifying the Law. If you are new, or as you might be aware, this is a educational program, an initiative brought to you by the government of Guyana to enlighten and inform you of the laws of Guyana, general provisions which may exist within the laws or penalties, but mostly for your benefit, so that you are kept abreast with legislation that is being passed and legislation which already exists on the statute books. As our Honorable Attorney General likes to say, ignorance of the law is no defense, and therefore the government thought it best to bring to you this program to ensure that you are aware of what is happening in the legal landscape within the country. Today with me, I have some special guests from the Financial Intelligence Unit and from the Ministry of Legal Affairs, who will go through with me a very technical piece of legislation, but a very important piece of legislation as well, as it safeguards Guyana from what some might call being blacklisted, and ensure that our legislative regime is in compliant with international standards. So that legislation is the Anti-Money Laundering and Countering the Financing of Terrorism Act. This act went through a lot of amendments through the years since its initial enactment, and one recent amendment was this year. This year, Guyana also underwent its mutual evaluation assessment from the Caribbean Financial Action Task Force, CFATF, and this legislation implements recommendations, among other things, to ensure Guyana is compliant. But to get into the nitty-gritty of it and to break it down, or simplify, as we say on this program, I'll just ask my guests to do so. With me, I have Mr. Matthew Langevine. He is the Director of the Financial Intelligence Unit. Ms. Yonette Scarville, she is a legal officer at the Financial Intelligence Unit, and Mr. Rommel St. Hill, he is our AML CFT officer, attorney at law, at the Ministry of Legal Affairs and Chambers of the Attorney General. Before we get into the program, I would just like you guys to, give us a little brief introduction of yourselves, starting with you, Mr. Langevine.
Well, thank you, Richard, for having us. It's a great pleasure to be here. As you said, I'm the director of the FIU. I've been there for the last 7 years. And I just wanted to, from the outset, commend you on a very, very interesting program. I am not a big television fan, but once I was invited to be a part of this program, I went about researching the program. And once I looked at the first episode, it got me hooked, and I ended up looking at 7 episodes on a trot. So very, very interesting, and it is a great pleasure to be here and a part of your program.
Thank you.
Thank you as well, Richard, for having me here this morning. As you mentioned, I'm Yonette Ramong at the work with the Financial Intelligence Unit. I have been there for the past 9 years. 4 of those years, I would have been working as the legal advisor, assisting the DNFBP sector. But for the last 5 years, I am working there as the attorney at law. So my job there would have allowed me to do extensive work with the AML Act, working with the various competent authorities. So I'm very happy to share with the public and yourself this morning on the AML legislation.
Yes, good morning, Richard. Thank you very much for having us, and to the viewers who are also watching this morning. So my name is Rommel St. Hill, and my role as the AML CFT officer at the Ministry of Legal Affairs is to ensure that the frameworks are more or less in cohesion. I also ensure that the legislation is up to date in terms of the FATF standards, and ensure that Guyana's interests are best looked out for in terms of how they interact with the international community in terms of anti-money laundering. So I attend the Caribbean Financial Action Task Force plenary. I will be at the Ministry of Legal Affairs for 5 years when March comes next year. And I also act as the Secretary for the National Coordination Committee, which is the policy-driven body with regard to actions taken with regard to AML-CFT within Guyana.
Okay, thank you all for being here. So I think the question that is on the lips of most Guyanese is what exactly is money laundering, and you know, what exactly does this legislation govern?
Yeah, that's a very good question. And to put it in the most simplest of terms, I like to refer to money laundering as where persons who commit crime try to use the proceeds of that crime and make it and to transfer it into the official financial system. So money laundering is where dirty money is tried or used to infiltrate into the official financial sector.
Right. And if you could take us through the historical overview of this legislation and the AML-CFT regime in Guyana, the legal and regulatory framework which governs money laundering.
So if I may speak on that, the main legislation on anti-money laundering and countering the financing of terrorism is the AML Act of 2009. That act would have undergone about 8 amendments to date. The act also works with regulations. To date, we have 3 regulations that would have been made to supplement that legislation. In addition to that, we have other related laws that are affected, and that affects prosecuting a money laundering offense. And so you would find other laws, related laws, like the Criminal Law Offences Act. We have the Mutual Assistance in Criminal Matters Act. We have the Anti-Terrorism and Terrorist-Related Activity Act, and a number of other legislation which affects the licenses of authorities. So that would be the framework. In addition to that, the framework was built based on, as you mentioned, international obligations, the CFATF, and FATF, which is the umbrella body that governs the standard of AML globally. And so Guyana would have been a party to a number of conventions and treaties, and as a result of our international obligation, we would have adjusted our laws in Guyana to be in compliance with those regulations. Guyana is also a member of the CFATF, as you rightly mentioned, and CFATF is what you call a regional style FATF body. And there are a number of bodies similar to that are associated with the FATF, and so Guyana as a member would have agreed to adopt those standards. So our background is basically from those conventions, the FATF and the CFATF. So I would allow any one of the other guests to
If I can
add
also
to that.
add to that, Richard, the purpose of Guyana becoming a member of the Caribbean Financial Action Task Force is not only to ensure that we're in compliance with the standards as established by the Financial Action Task Force, but also to ensure that the regime that we build, the legal machinery that is there, is established in a manner that allows for us to effectively protect our financial system from launderers, because the impact of criminal proceeds entering the financial system has a very debilitating effect can have a very serious effect on the economy, because criminal proceeds affect the ability of legitimate businesses, to put it in simple terms, to function effectively. So it is in Guyana's interest to protect its financial sector from money launderers and terrorist financiers as well. And so to do that effectively, we need a robust legislative framework, which is essentially guided by the best practices and standards established by the Financial Action Task Force and copied by the Caribbean Financial Action Task Force, which we are a member of, and the other FATF-style regional bodies around the world.
Yes, if I may, just to add, because of the dynamic nature of AML-CFT, these laws actually cross-cut into other legislation. So, for example, you have considerations in terms of the Tax Act, in terms of the Bank of Guyana, as Janet alluded to, some of the other acts. But similarly, we had to create, let's say, a new or upgrade framework. So there's a new Real Estate Agents and Brokers Act, which has some very important AML-CFT provisions. And there's also Guyana Compliance Commission Act, which will also seek to supervise some sectors which weren't supervised before, such as attorneys at law, accountants, as well as non-financial trust and company service providers. Because under the FATF, the recommendations have that these sectors should be supervised as well. So it's not simply a static piece of legislation in a regime, but it cross-cuts into all sectors, both financial and those professions who are not per se financial, but they have some type of financial basis. Accountants and lawyers in terms of looking after businesses, companies, dealing with land transactions. So it is a wide spectrum. So it's not simply a criminal regime per se, but it's also a licensing and regulation regime as well too.
Well, thank you. So it's not just this sole act either which governs the sector. And what is the necessity of having such legislation within our legal architecture? I know you alluded to it a little there, Mr. Langevin. So if you could take us through that.
Yeah. The legal framework is just one part of building an effective compliance regime. If I may go into the structure of the framework, the legislation is the foundation. That's where it starts. If you don't have the correct and the all-encompassing, the multiple pieces of legislation that governs the entire regulatory framework, it will not meet the minimum standards as established by the Financial Action Task Force. But it's much more than the legislation. From the legislation, we then go into the relevant agencies that that are a part of this framework. Some may say it starts with the FIU, the Financial Intelligence Unit, where the FIU is established as the primary agency under the AML-CFT Act, Section 9, that has the primary mandate of receiving, analyzing, and disseminating intelligence relating to financial crimes, money laundering, and terrorist financing. We also have, as part of the regime, reporting entities. Those are entities listed within the Act that are required to provide reports to the FIU, and those reports we have multiple reports that they send to us, including threshold type reports, transactions over a certain limit, suspicious transaction reports, or terrorist property reports. So reporting entities from both the financial and designated non-financial businesses and professions, Rowan spoke about the lawyers and accountants, are part of that regime. Reporting entities have a major role to play, as described by the law, in putting up defense mechanism. They're the front line to the public in bringing intelligence to the FIU with respect to suspected money laundering or suspected financial crimes being conducted within the financial system. Then we have supervisory authorities, of not a very important part of the process. The SAs, as we refer to them, are the entities responsible for monitoring and ensuring that the reporting entities are doing everything that is required of them as is clearly outlined within the AML-CFT Act. The Act specifies very clearly what a reporting entity is expected to do, whether it is respect to record keeping or KYC, knowing your customer procedures, ensuring that you know who you're dealing with as businesses, ensuring that they are reporting to the FIU as required by law. So the supervisors and every single sector, financial and non-financial, has a supervisor. In Guyana, we have 7 different supervisors, and the recently passed Guyana Compliance Commission Act will ensure that another supervisory authority is appointed in the Guyana Compliance Commission when it is set up, and they will then supervise the DNFBPs, including attorneys and accountants. Other than the supervisors, we also have law enforcement, very important part. And in Guyana, based on the structure, the Special Organized Crime Unit is the competent authority designated to investigate these types of offenses, financial crimes. The FIU, which was enhanced in structure legally in the recent amendment, is the body that, based on intelligence provided by the FIU, will go and investigate and develop evidence that will then be used to hopefully prosecute and get convictions with the support of the DPP, which is another key agency. There are a number of other competent authorities that are involved in the AML-CFT framework, including like the registries, which the FIU can get intelligence from to help build cases. And so it's a wide framework, it's all encompassing, and it ensures for a level of effectiveness which is in compliance and satisfies the expectations of the international community.
If I may add to what Matthew has just said, another important factor in developing this regime is based on a number of risk assessments. The country would have conducted to date about 5 risk assessments. We had a national risk assessment to see the level of risk posed by money laundering, terrorist financing. We had a risk assessment on the NPO sector, a risk assessment on the legal persons and virtual assets. I think currently ongoing is a risk assessment on the extractive sector. So coming out of these risk assessments, there is a national policy which was developed based on recommendations. So those recommendations would have been factored into the regime, and we would have seen the recent past legislation which included some of the recommendations coming out of those risk assessments. So that sort of answers some of the why. So that's my take on that.
No, you have anything to add, Roman?
Yeah, sure, no problem. So to build on that, it's very important to kind of describe what the risk assessment is supposed to do. So let's come from the top. So there was a national risk assessment in 2021, and based on those findings, we found that we needed to do a number of sectoral risk assessments. So such as the nonprofit organization, because the FATF wants to make sure they're not abused for terrorist financing. So you have to do a specific risk assessment for that to ensure that they're not being abused. But I would like to speak specifically to new and emerging trends, because it is very important in this dynamic industry. So the virtual assets are virtual asset service providers. That will cover things such as cryptocurrency, for example, which is a very topical area which the world more or less is still grappling with. So because Guyana does not have quote-unquote legislation to deal with licensing and governing cryptocurrencies and the dangers which are involved with it, I'm sure you would have heard of Sam Bankman-Fried and FTX, where he was actually found guilty, and I think it's Binance. He had to
recently
cut a deal for $4 billion US, because persons have lost a lot of money not understanding these technologies. And it's not simply a case of it being used for fraud. Persons go on the dark web and they use cryptocurrencies to purchase drugs, basically purchase credit card numbers, child pornography. So a lot of nefarious activities go on the dark web. And when you use cryptocurrencies, if you don't have a proper mechanism, you can be anonymous and untraced. So because of that, Guyana has actually banned the use of virtual assets and virtual asset service providers until December 31st, 2025, where it is expected in that framework that Guyana will be able to do a feasibility study to find who's the proper supervisor, to train SOCO and other supervisory authorities so they can investigate, as well as seize cryptocurrency as an actual asset. And that way Guyana can now be ready to capitalize on that, because it's not a case that you can shut the door, it's the way the world is going. But as an emerging economy, you have to face the reality that you need more experience in dealing with matters related to virtual assets and even financial inclusion to some extent, because this is still a very cash-based economy. When we traveled to the US the other day, you basically check out with your own card and that type of stuff. They don't even want to take cash when you're going to the counter to check your bag. So there's going to be a lot of evolution into the framework. So it's amazing how all of this is actually intertwined.
Right. And what might be some of the consequences for failure to implement this specific framework?
Very important for the country to know this, because we hear that when we get out there. We will recall, prior to working at the FIU, I worked in the financial sector, and I always recall around 2010, when Guyana went through its third round of mutual evaluation, and due to the inadequacies of the legislative framework at the time, for various reasons, Guyana was actually gray listed, and it had a very serious impact on, as I like to say, the ease of doing business in Guyana. And I know the government is very focused on that reality. And so, as an emerging economy, one of the first things we think about, we want to make sure that it's easy to do business in Guyana. Guyana being gray listed by the Financial Action Task Force due to having what we call an inadequate AML-CFT structure can have a very serious impact. Back in 2010, 2011, and those years when we were gray listed, one of the things that was very topical was the loss of corresponding banking relationship, de-risking as it is referred to. And several international banks severed relationships with local banks, making it very difficult and in some cases very expensive to do business, international type transactions, wire transfers, for example, incoming transfers to receive payments for exports. It became a lot more difficult and complicated. And that's one of the most important things that can affect Guyana if we are seen as not having a robust and adequate and effective AML-CFT infrastructure. So I'd just like to start with those two, for example, the ease of doing business and the ability to do certain transactions if we don't get this right.
Another factor is reputational risk, because and it has a cascading effect, so that once your country is blacklisted, countries, they just don't want to do business with you, because associating with a country that is blacklisted would kind of have an effect on them. So that is another factor to consider in terms of the consequences of not complying with the FATF standards.
Yes, and the interesting thing is, you may say to yourself, okay, so why don't we just comply? But it's such a technical process that if you allow yourself to fall into, let's say, a very deep review process, it then becomes quite difficult to get out of it, because you come under severe scrutiny, and it's always better to be on the front foot and be proactive, to put your measures in place to show that you are compliant, rather than having to follow measures that, let's say, the persons that are assessing you would have put, that may now be difficult for you to reach that threshold. So it's not a very easy process to get out of, so it's always better to try to do what is necessary proactively to avoid those consequences. And unfortunately, a number of our CFATF member countries went through that quite a bit. Recently, Trinidad and Bahamas came off the grey list. I think the Cayman Islands will be coming off if they're not already. But Barbados is still on there. Jamaica is still there. Haiti is there for a different reason. So you could end up within that threshold where you're monitored specifically by the FATF.
I know, Mr. Laundering, just now you mentioned a lot of different bodies that participate in this process, supervisory and bodies and what's not. But does the legislation create an authority or an umbrella authority which governs or supervise these agencies and bodies?
Yes, Richard. The AML-CFT Act as amended, one of the amendments specifically, I believe it might have been the 2021, but whatever one it was, specifically established a national coordinating committee. And that national coordinating committee is chaired by the Honorable Minister of Legal Affairs and Attorney General. It comprises a number of agencies that are very involved in this process, including the FIU, SOCO, the Guyana Revenue Authority, the CCDO's office, the Chief Corps and Development Officer, the DPP chambers. And these agencies, we sit at the policy-making level. The representatives from the supervisory authorities, all 7 of them, have a seat at that table. And the legislation also makes provisions for the committee to invite other relevant parties and stakeholders to specific meetings to address issues that are affecting the country that they may be able to provide input and guidance on. So when we sit at that National Coordinating Committee level, we develop policies and strategies to help develop a robust regime to make sure that Guyana is legally and legislatively compliant, to ensure that the various agencies are executing in line with the mandate of the government in terms of protecting Guyana as a financial system from money laundering and terrorist financing. And so that's a very important head of the framework, and as I said, it's chaired by the Honorable Attorney General, and we meet quite regularly. Within the last few months, with Guyana being subjected to the on-site visit, we've been meeting more regularly, and it demonstrates the collaboration and the need for collaboration in ensuring that we are effective and we remain compliant.
Right. The common man, when they go to do financial transactions, for example, MoneyGram or Western Union, they are required to present certain information, and you would read a little notice and say this requirement is pursuant to the AML-CFT regime and legislation. If you could take us through some of this, and why is this the necessity of this?
All right. The legislation, as we said, is quite comprehensive, and it has specific roles for the reporting entities. Now, these reporting entities, if I can talk to you about who they may include, on the financial side, we have banks, we have non-bank financial institutions, for example, like building society and trust companies. We have cambios, we have money transfer agencies, we have insurance businesses, that would include insurance companies and brokers. We have recently added, based on the recent amendment, payment service providers. That's like what's the GT? MMG. So we recognize that there is the potential of those financial institutions to be used to launder funds. And on the non-financial side, we refer to them as DNFBPs, designated non-financial businesses and professions. Some of those regulated entities would be things like auto dealers. And as we went through this process, it only occurred to us how many auto dealers we have registered in Guyana. And one of the amendments in that 2023 amendment widened the type of auto dealers that are now required to be in compliance with the requirements with the legislation, from being used car dealers to all auto dealers. And auto dealers, you have pawn brokers. It's now extended to money lenders based on the recent amendment. We have traders in gold dealers, to put it in simple terms. We have diamond dealers, and a number of others within the designated. And one of the things specified within the legislation as requirements for those entities when they engage with their clients is to do certain specific. One of it is KYC requirements, and those are the things that always comes up with customers when they engage. They're usually asked for identification, and the reason for that is that when you do business with the public, you must be able to clearly identify and verify who you are doing business with. And that is important for the purpose of investigations later on. For example, if the FIU recognizes that certain transactions were conducted and it may be linked to a crime or to proceeds of crime, and we want to share that information with the Special Organized Crime Unit so that it can be investigated, they will need to know specifically who they're searching for. So we need to go back to that entity and get specific verifiable information so that that investigation can be conducted. We want to be able to get information on how to contact them. So the entity, whether it's a bank or an auto dealer, should be able to tell us, okay, well, we have been able to establish that this person lives here and this is where they work, and based on the information that we were able to receive from them, this is what they should be earning. So as much information that is possible and it is provided for in legislation based on Guyana's law and the international standards is expected to be collected by the reporting entities when they engage with the public. So there's a very specific reason for this, and this is to ensure that you as a business know who you're dealing with. KYC, and for higher risk customers, the legislation also provides for how do you deal with customers that are generally considered of a higher level risk for money laundering. For example, cash intensive businesses, right? You're required to do what you refer to as enhanced due diligence, all right? Which will require for you to have a deeper and greater understanding of that customer and their earnings and how they've accumulated their wealth. All of that is covered in the legislation, and so that is why the reporting entities and their compliance officers especially, but also all of their staff, are expected to know and understand their compliance obligations and what to expect and what to ask of their clients and how to go about doing this. And the legislation is very clear on this.
Coming out of that, what is important too is that the reporting entities do risk profiling of their customers, so that in applying the customer due diligence measures, they would apply according to the risk base of the customer. So it should really be risk based. So the same application of enhanced due diligence should not apply, for example, to a customer who's doing a simple transaction. So it's important that they do the risk profiling so that customers would not be complaining about the overly regulation from some of the commercial banks. So for one of the complaints, I think they should focus on having policies and procedures that allow them to apply their measures on a risk base.
And the legislation makes
Provides for
provisions
that
for
as
this.
well.
Yes.
That's a requirement.
Okay. Like you've mentioned earlier in the show, there has been many amendments to the AML-CFT Act. 2021, 2022, 2023, almost every other year we see some sort of amendment, and this is clearly an evolving, living and breathing legislation. What is the necessity of all of these amendments, and if you could touch on some of the things that they introduced through the years to make us compliant or for whatever sake it's necessary?
All right, let me start off. I will look at the why, and I'll get Janet and Romel to walk you through some of the key amendments made over the years. One of the most fundamental things about this legislation and about this regime is the fact that AML compliance is not static. What we see in terms of risk and the amount of learnings we experience on an ongoing basis helps us to recognize what we need to change. Romel mentioned earlier the implications of virtual assets, which is a relatively new concept, and which, for example, Guyana really jumped into having serious conversations about this relatively late. And so that's one of the amendments that we had to look at and put measures in place to deal with. And so fundamentally, a lot of the amendments are driven by the change in landscape for money laundering standards, money laundering risk, money laundering exposure, not only in Guyana, but internationally. Another element that contributes to the ongoing changes is based on the mutual evaluation process. Guyana expends a lot of money in terms of attending those mutual evaluation, those plenaries, and observing the evaluations of various countries over the years, and we learn from them. I think it's money well spent. And as we see what countries face and what their legislation may seem weak in, we learn and we use the opportunity to ensure that we take corrective measures in advance of being evaluated. And that's why the most recent amendment, we ensured it was completed well in advance of our on-site mutual evaluation visit. Another factor that contributes to the amendments is based on feedback from and based on what we see in other countries. For example, one of the things we did in advance of this most recent amendment is that we sought perspective and input from CARICOM Impacts, and they were very helpful and supportive of helping us to develop, for example, one specific piece that dealt with asset recovery and asset management. And so we look at legislation across other country, what is working well, and we make changes that we believe will help to ensure that we in Guyana have the most modern and the most robust regime that is possible in these parts of the world and across the world as well.
Yes, so for the third round mutual evaluation, that process required Guyana to have technical compliance. Technical compliance is basically having the laws, regulations, and institutional framework in place. So coming out of that third round mutual evaluation, Guyana had to develop an action plan. And the action plan would have identified certain loopholes in the legislation. So the 2015, 2016, 2017 legislation would have been based on that third round mutual evaluation and the recommendations that were made from the CFATF, because we had to exit that process, and it was a follow-up process, and during the various follow-up sessions we had to be producing legislation to show that we would have been compliant. So those earlier legislation basically were on the technical compliance for Guyana. The recent legislation that we have seen, some of the new amendments include things like enhancing the law enforcement agencies. So for example, section 24, which dealt with production orders, that application was made only to a judge in chambers. We have seen with the new amendment that that application can now be made by the FIU or SOCU, SOCU is the Special Organized Crime Unit, to a magistrate. Another important change is that the offense of money laundering, it requires you having a predicate. And in our law, we refer to it as a serious offense. So added to that definition was the concept of an unlawful conduct. And what that did is to allow you to now consider money laundering or a predicate offense for money laundering on a wider basis. Previously, what we had was a threshold sort of framework where you had to commit a crime that is the least 6 months imprisonment. But now with the definition of unlawful conduct, you can now consider any offense almost for the purpose of money laundering, which is very important. Another important factor is that the SOCU is now recognized in the law. Previously, SOCU, we know it's a department of the Guyana Police Force, but it was established by a cabinet memo. So now that is expressed in law, there is no issue as to local standard before the court. The functions are also clearly defined, and so SOCU is now designated as the unit to investigate and prosecute money laundering, terrorist financing, or similar offenses. So with respect to the changes, Romel may be able to add some more to some of the new amendments.
Yes, both of them were actually pretty comprehensive, but I'm going to add some more. So as John would have mentioned, there's some asset recovery provisions. The Honorable AG would have noted basically when he came into office that this more or less needed to be revised. So we actually got quite a bit of help from the Regional Security System Asset Recovery Unit at the National Center for State Courts. So we upgraded it to put in best practice. We also consulted with the law enforcement agencies such as SOCU to ensure that the provisions are much more effective. So like the restraint provisions, for example, they can actually seize the asset so that the person cannot have access to it. We updated in terms of cash seizures so that if a certain amount of cash is found in the commission of a crime, that cash could be seized and the person would more or less have to prove that it's not from the proceeds of crime. We also updated the terrorist financial sanctions aspect of it. So that is a very technical area where if you end up on a United Nations sanctions list or Guyana designates you on a local list for terrorist activities, if your name shows up on this list, the bank, or let me just say any person, or refers to any person, is supposed to freeze your asset right away. And it's very technical too, because not only does it deal with finances, like how you think of money, but for example, persons may be borrowing items such as gold, which is another asset. So you have to take all of those factors into consideration. and that persons may be actually directing them to do these things. We also improved the international cooperation framework. So now it's a lot easier to transmit and receive information in order to fulfill those duties. We also use the Act to amend some other acts. So the Anti-Terrorism Act, it now has a anti-terrorism unit and an anti-terrorism task force, which can therefore focus on terrorist-related activities. Guyana's risk for terrorism is relatively low, but as you know, we don't live just in a bubble. You know, there's a lot of globalization going on. So we have to be ready just in case something happens. So the legislation has been done to ensure that we're ready in case something like that happens. So the confiscation regime looks to be much more improved. Terrorist financial regime, money laundering laws, they're more or less looking compliant with the recommendations. So what I'm saying looking is because we are actually under evaluation and we are currently discussing a report. So we can't discuss the results officially, but we can say that we're confident that we will do quite well when this report comes out.
Right. And this legislation seems to cover a lot of a wide scope of stuff, because you mentioned it also includes criminal offenses.
Yes, because a money laundering offense requires you to have a predicate, which is an offense that you committed before you can launder the money.
Right. And the penalties, which there, it also creates penalties for failure to abide by the legislation.
Yes, it would have, yes, the offense of money laundering carries very high penalties. There's also penalties included for breach of confidentiality and tipping off, because that is very important to the legislation. So the penalties that were included, they're what we call proportionate, effective, and dissuasive, because those are the language used by the 𝘰𝑓𝑎𝑡F and 𝑓ATF. So the penalties are very huge. You have penalties ranging from $1 million for tipping off and 3 years in prison. So the penalties are very dissuasive in the legislation.
And while we operate on a global level and must take into consideration the recommendations of the �㈫F and 𝘰𝑓𝑎𝑡F and other international organizations when creating this these types of legislation, I'm sure that the legislation must also be tailored to fit our local circumstances and our domestic necessities. So if you could just take us through briefly the process of drafting the recent amendment acts and you know, the consultative process that it underwent before the bill was finalized.
Yeah, I could take this one. So I'm just going to do it in summary because there were quite a number of steps. So we started at the National Coordination Committee level, where persons would have more or less brought forward perhaps issues they would have had with their acts or with the act, or things they would need to see in the legislation. We also would have examined the 𝑓ATF best practices and standards. So in examining these, we would see where the gaps and the loopholes are. So naturally, of course, it's not a matter of you just taking a law and you're throwing it on people in a draconian way. So a number of consultative processes took place. Specifically, the Real Estate Agents Authority. There was extensive consultation with this body towards putting this bill together, as well as having it eventually as a supervisor for real estate agents and brokers. Currently, that supervisor is still the Guyana Revenue Authority, but there's going to be an eventual evolution as the Real Estate Agents Authority becomes more familiar with the operations, to then have them supervise their persons as well. So we, as a body, of course, we went to various reporting entities and we partner as well. So for example, when the Gold Board would have had their consultations with the gold dealers, we would have gone with them. We would have had an outreach for nonprofit organizations as well. And quite recently, we had a discussion with the Guyana Bar Association in terms of how we expect the Guyana Compliance Commission bill to because it's passed, to function. And we're actually supposed to have continued meetings because we want to ensure, of course, the application, whilst it meets the best practices and standards, that it's still applicable and workable for persons within Guyana as well, because that is the main important aspect of the framework.
Just to add to, in terms of the legislation, I mean, you mentioned the word draconian, but just to talk about the constitutionality of the legislation, is that what is important is that money laundering is an offense like any other offense. So the rights to the defendant is not affected. The defendant has a right to a fair trial. He has a right to an attorney, and so all those constitutional provisions with respect to what the defendant should expect are provided in the AML Act. So it is not unconstitutional as would be believed by some of the populace, members of the public and so on.
Okay. Well,
Thank you, Yana.
so we don't have a lot of time left. So here I would give each of you the opportunity to share your general thoughts or comments or anything that you would like to share in relation to the legislation, or anything that we would have missed. Starting with you, Mr. 𝘔𝘶𝘴𝘪𝘤.
Well, I think most importantly is we believe this legislation is helpful to Guyana and the whole issue of ensuring that our financial system is protected. You talked about the importance of the engagement and consultation process. I think that was very extensive. We got a lot of feedback both nationally and internationally. And so we want to encourage all stakeholders to get familiar, because implementation and full compliance can only happen when all persons, and again, this is why this program is so important. Persons need to know and understand not only what is in the legislation, but why, and I hope that we provide some clarity as to why this is important. But we need all stakeholders to really embrace it and implement it. Whether you're a reporting entity, I know the supervisors are fully on board. We call on the regulated sectors that are not necessarily fully regulated or fully compliant to really embrace this, not only for themselves and the financial system, but for Guyana. We've tried to explain the implications of non-compliance. That doesn't only affect you, the entity, it affects every citizen in Guyana, because it affects the ability for us to do business in a speedy and an efficient way and in a cost-effective way. It affects the ability to do business easily. And so we want to make sure that persons understand not only the what's but the why's, and we want to ensure that there's wide compliance at every level. So we look forward to that, and we want to ensure that we are available. So again, not only the FIU, but if you have continued questions and need any further clarification with respect to any element of this legislation or the AML-CFT regime, reach out to your supervisor, reach out to the FIU, reach out to the AG's office, send an email, and we will try to have your questions and issues addressed.
I embrace the comments made by Matthew with respect to all stakeholders supporting the process. I would also like to see that the necessary competent authorities just put systems in place to ensure that the new amendments are effective by having policies and procedures, and they can have the necessary budget allocated to ensure that the systems would work, and that the resources and the technical expertise would be there to embrace the AML regime in Guyana.
Yes, I would say it's very important for the public to remember the main basis for AML-CFT, which is more or less to take the profit out of crime, to ensure that persons who are laundering money or who want to participate in the financing of terrorism, that there are laws and penalties for those who seek to do so, and that there's recourse for deterrence. So let's say a person commits a crime and they're able to get a whole set of assets, and they say, well, I'm just going to go spend 10 years in jail, I still have my $20 million house there. If you can prove that these are proceeds of crime, you can actually seize the asset, and then the government can sell it and then use those funds to do important things like buy police vehicles, and further encourage persons to be involved in the fight against crime and to enable their authorities to do so. I know there have been a lot of amendments, and I believe the AG is on board with this. So after we would have completed our evaluation process, we're going to do a consolidation of the legislation so that it is therefore a lot easier to read instead of different amendments. And more or less at the Attorney General's chambers, and I believe I could speak for the FIU. We're open to going out there, doing sensitization sessions to further enable persons to understand the regime of AML-CFT, and that way we can get feedback from persons basically in terms of what's going on in society and how we can, how do I put it? So if there's a need for simplifying measures, let's say a person lives in the interior, it's harder for them to get a proof of address, they can perhaps have a 𝘱𝘀𝘪𝘳 a letter for them. So that all that goes back to the customer due diligence process. So it's meant to operate in a way that's sensible, not just simply because this is a recommendation, it has to be this. It can be fulfilled, but in a sensible way, which is applicable to the country. So that's just what I want to say of these priority works. It's an important regime, and it's one which we have to follow in Guyana. Do not shy away from it, and we're here more or less to educate the public into how it's supposed to work.
Okay, well, thank you all for being here today and going through this act with me, and for all the information which you would have shared. I know this isn't the glitz and glamorous work on the forefront, but this is the more technical, tedious work which you guys do, and thank you for that as well, to ensure that the country remains compliant and that we are above board when it comes to our financial regime. I think that is all the time that we have for today. Unfortunately, I might have to ask you to reappear on another episode because you do have quite a bit to share, and you've mentioned other legislation as well, such as the Compliance Commission Act. You definitely would have to reappear to go through those, that one with us. So thank you again for being here, and that has brought us to the end of this episode of Simplifying the Law. Until next time, I am your host, Richard Bainey. Thank you for joining us.
Thank you.